deadline? August 1st.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Busk. Good morning.
Good morning, Your Honor.
Good morning, Judge.
Good morning. I don't know what the weather's like. I assume you're either in Seminole or La Mesa in San Antonio, but Eastland County's had 5 inches of rain in the last 48 hours, so it's pretty wet and soggy. I think that may be statewide. With that being said, we're ready to proceed with our first case this morning. The court will call at this time 11-19-274 CR Demas Gonzalez versus the state of Texas. Ms. Orr, are you ready to proceed?
I am, Chief Justice Bailey.
You may.
Thank you. Chief Justice Bailey, Justice Trotter, Justice Williams. My name is Cynthia Orr, and along with Dante Dominguez, I represent Demas Gonzalez, who was convicted after a jury trial of murder, sentenced by the jury to 45 years, and his motion for a new trial was denied after a hearing. This case is a little unusual in that we're revisiting factual sufficiency review, Your Honor. As cited at page 32 of our brief, in cases in which defenses are raised, receive both factual and legal sufficiency review. This was confirmed expressly by the Court of Criminal Appeals in the Butcher case that we found as we're preparing and filed last evening, that's still expressly the manner in which we review these cases. So we look at the evidence in a neutral light, not in a light most favorable to the verdict. And we determine whether the state has met its burden both of proving guilt beyond a reasonable doubt and disproving defense of another beyond a reasonable doubt. And we do that by determining if in a neutral light, considering all the evidence, was the evidence weak that the state disproved self-defense or defense of another? Was it clearly wrong and manifestly unjust to convict? Was it obviously weak so that it undermined the jury verdict or proof of guilt? And although proof of guilt perhaps adequate alone, was that undermined by other evidence? And so looking at the evidence in that light, we also evaluate it from a hypothetically correct jury charge under Malik. So this court will evaluate the evidence by considering the right to continue.
Ms. Orr, since your time is limited,
yes,
we are familiar with the standards. Why don't you explain to us why you believe under that standard you're entitled to the relief you request?
I will do so. So we look at the evidence from the standpoint of the defendants, and we look at it from the standpoint that here, Bernie Gonzalez was at his home. Bernard Kennedy arrived and he testified that, as Bernie did, he almost hit me with his truck. After that, there's an altercation in which Mr. Kennedy goes and he attacks him with a knife. And Bernie testified, I thought I was going to die. And his father said, don't shoot my boy, where my client could hear. The grandmother starts screaming from the porch, hurry up, in Spanish. And hysterically, in a manner no one had heard her scream before, also heard by my client. In a fight, Bernie's dad is on top of Mr. Kennedy trying to calm him down. And Mr. Kennedy bites him in the chest, so he's bloody through his t-shirt and it leaves indelible marks on his chest. He won't let go and he asks his boys to help him. And those pictures of those injuries are in the record. And when he thought he'd calmed down, to let him go, when he thought things had settled down, He let Mr. Kennedy up, and Mr. Kennedy attacked again. That's when he brought the knife. That's when he tried to stab the boy. That's when he threatened his life where he thought he was going to die. And when my client saw this and hollered out, "Get out of here," using expletives, Mr. Kennedy made it abundantly clear, I'm not leaving. I'm going to go and get some more of my people here, and we'll see how this comes out when they arrive. He said, "I'm not leaving," expletive. "I'm going to kill these MFs. I'm going to kill these people," not just one person, but the Gonzalez family, then, there, and present. Waiting in the road with his truck, the first deadly weapon that he had used, still running, he was on his phone, apparently calling for this increased threat force. So armed with his truck, a knife, then a brick that Bernie had thrown at the truck, I think in a poor attempt to get him to leave, he got out of his truck and threw the brick, striking the fence of the home, also striking Bernie in the head.
Where was he situated when the brick was thrown?
He was apparently by his truck because the brick had hit his truck, Justice Trotter. So apparently he was by his truck when he threw the brick at the home, hitting the fence and hitting Bernie Gonzalez, who was still on his property.
And was the truck parked in the roadway?
It was, Your Honor. In addition, in the state's brief, this is when there's another fight between Bernie and Mr. Kennedy. They're engaged in combat again. And the state concedes at page 40 of his brief, this is when my client begins shooting, defending his nephew, defending the rest of his family, who Mr. Kennedy has made clear, we're going to see how this is going to go when my people get here, because it took 3 of you to beat me up. When he responded to Mr. Gonzalez, who said, "Get out of here," expletive, and he responded, "No, I'm going to kill these expletives. They jumped me."
Explain what deadly force was being used against those that Mr. Gonzalez ultimately shot with the AK-47.
The deadly force used against his family was the truck almost hitting Bernie, the knife being used to within the zone of danger to try and stab him. In fact, Mr. Gonzalez specifically said after shooting, he shouldn't have come on the property and tried to stab my nephew. He threatened to bring others with him. He didn't specify what additional force they would bring. And there was an indication, Justice Trotter, that he had gone back to his truck, that he'd lifted his arm, and there was a question, was he seeking to get a gun? Was he seeking to use a gun? And so from the perception of the grandmother, from Mr. Gonzalez, from Bernie, I thought I was going to die, from Gregory, Kennedy's intent was clear. He intended to use deadly force against each of them.
And as Mr. Gonzalez's family members were being attacked, and as he opened fire,
yes,
were Mr. Gonzalez's family members on his property?
Yes. Yes, they were, Your Honor. And there's a question that some of the countervailing evidence is one witness, a Mr. Riddle, who was in a truck some either 10 or 66 yards behind Mr. Kennedy's vehicle, depending on which version of his testimony you believe. He observed someone with long hair, and clearly Mr. Gonzalez did not have long hair, that he perceived to be the shooter standing in the road who fired a shot after Mr. Kennedy fell. But the testimony from every other eyewitness is that there were no shots after Mr. Kennedy fell, that Mr. Gonzalez did not continue shooting, but that we still had this posse coming, which arrived very shortly thereafter. And it's very interesting that no one could see. Go ahead. Sorry.
I'm sorry. Where did Mr. Kennedy fall?
Apparently, and there's a varying testimony from the folks that arrived at the scene. The EMT driver said he almost was on top of him when we pulled on the right side of the road next to Mr. Kennedy's truck, and he estimated he was 1 foot off the paved asphalt, that his feet were 1 foot, varying to folks saying he was in a bar ditch, was about 3 or 4 feet in from the improved asphalt of the road.
Okay, did Mr. Kennedy ever demonstrate that he had a gun?
We only have the evidence, Justice Williams, of him raising an arm up when he went back to his truck and was trying to get in it. No gun was found in the vehicle, but Mr. Kennedy's posse, that is Mr. Maxwell and Mr. Manuel, were in that truck rummaging around in it, and Mr. Maxwell left the scene before the police could determine what he'd taken from the vehicle, if anything.
Did Mr. Kennedy have an open knife in his hand at the time that he was shot?
We don't know if the knife was open, Justice Williams. We do know that it was in the body bag with him, so it had to be with his person, but we don't know the state of that knife at the time he was shot.
Okay.
It was with him, though. And then what we do know is there was also this threat of additional force, and we know from the Jordan case that these individuals that knew additional people were coming didn't have to be under attack from them at the time to use force to against the increased group threat. Reasonable to believe that they brought additional guns or were bringing guns. In fact, Bernie, in his 911 call, tells the police there's more people at the scene, they've got guns. And as I mentioned before, Bernard Kennedy raised one arm, perhaps as if raising a gun. Mr. Riddle couldn't tell. And also officers testified, and lay people, that you couldn't see behind Mr. Kennedy's truck from the Gonzalez property. That would be Officer Perez, third on the scene, Mr. Manuel, who arrived there before the police, Officer Peterson, who was first on the scene, and the EMT, who was almost on top of Mr. Gonzalez when he pulled beside his truck to attend to him. When I opened my door, I was almost on top of him. 15R146. And then the wife, when she arrived, as the police were arriving, also could not see him where he lay. So looking behind there, Mr. Gonzalez couldn't see if others were arriving, couldn't see where Mr. Kennedy was. And Mr. Riddle confirmed there were ricochet shots, which becomes important in my argument regarding the exclusion of the defense witness, Mr. Clements. And then he backed it away even further from the scene, which is a sensible thing to do when shots are going off.
Ms. Orr,
Yes.
you've got 2 minutes and 40 seconds left. Could you please address your new trial issues for us?
Sure. One of those was with regard to the fact that we have this one juror who was polled in a manner that the case law says would imply or encourage his coercion. The objection was made in a bystander bill during the motion for new trial that, in fact, Mr. Barrera, Mr. Hurley were concerned about coercion, concerned about the validity of his verdict, and concerned about his situation, that is, being the minority juror. And so they asked for the court to inquire, and the court said, I'll leave that for the appellate court to sort out. I'm not going to inquire of them. But we put on Mr. Arredondo's affidavit that he did not believe Mr. Gonzalez had the state of mind to commit murder, and so he disagreed with the verdict. And yet, after this polling, where the lawyers expressed concern, he came back within 26 minutes with a guilty verdict. In addition,
Are we even able to consider that affidavit for purposes of appellate review?
I made it a bill of it, Your Honor, because the court refused to admit it in evidence during the motion for a new trial. And so I made it a bill to demonstrate to this court what his testimony would have been had the court allowed the inquiry. But one of your options is to remand for us to complete that motion for a new trial hearing.
But essentially, the purpose of that affidavit or its content was to inquire as to the juror's deliberative process, correct?
No, Your Honor, it was to inquire as to the fact that he felt coerced to justify further inquiry. And Your Honor, since he was so emotional, we're allowed to inquire into some deliberative processes, particularly coercion, influences, and also if there was discussion of racial animus or things of that sort. And so those are the sorts of inquiries we would make if permitted to make those inquiries.
But none of those things are reflected in the affidavit.
No, Your Honor, they are not. But those are the sorts of inquiries because we were concerned about coercion, and that would be what we would inquire about, not the deliberative process, but was there coercion and did it come in the form of racial animus as well? So those fall under that category, and that's what we raised. I would also...
You're
Yes.
out of time. If you'd please wrap it up.
Thank you. Yes, I'll also say I'm particularly concerned about the exclusion of Mr. Clements, who could have proved up this ricochet theory that Mr. Kennedy was shot when a bullet ricocheted as he was facing forward, and that all this stuff about shooting after he was running is really irrelevant. So he was deprived of his defense and deprived of that very important jury instruction, the right to continue shooting until the danger had passed, including from this increased force. Thank you, Your Honor.
Thank you very much. Mr. Massey, are you ready to proceed?
I am, Your Honor.
You may.
May it please the court and counsel. I'm going to address the appellant's evidentiary issues first. The appellant claims here that the victim or that family members of the Gonzalez family was attacked by the victim with a knife. There was conflicting testimony as to whether or not a knife was seen. Officer Aguillo did testify that there was a knife involved in the case and found on the victim's person. However, members of the Gonzalez family testified that they couldn't tell whether or not they saw a knife or not. Bernardo's father said, "Don't stab my boy." But there's conflicting testimony as to whether or not that was even attempted to be, that Kennedy was even attempting to do that in the midst of a scuffle and a fight in their front yard.
There's disputed testimony on the issue.
Correct.
Is
And
it why we have juries so that they resolve any conflicts in the issue?
correct, Your Honor. So the jury didn't find those facts to be true or dispositive. As far as the defensive instructions are concerned from the legal aspect, the key thread that runs through all of appellants' claims with regard to their desired defensive instructions is that the use of deadly force was, quote, immediately necessary in order to scare off Kennedy. The evidence, as the jury found it, was that Kennedy was fleeing the scene at the time that the appellant started shooting Kennedy. I would argue, the state argues, that it's not immediately necessary to use deadly force on someone who is running away from you, regardless of what had happened up to that point. And Kennedy, as appellant, had
Mr. Massey?
he threw the brick at Bernardo. Kennedy was at his truck when Bernardo threw the brick at Kennedy. And at that point, that was the point in which Kennedy was attempting to leave the scene. So regardless of any factual or legal sufficiency standard that is raised by the appellant in this case, the fact of the matter is that the desired jury instructions on self-defense are not required to be included in the jury charge. And in fact, in the original jury charge, as it was submitted to the jury, contained instructions on self-defense based on 932. And in the appellant's brief, with regard to a nighttime defense of property under 942, that also contains the requirement of an immediate necessity in order to use deadly force to defend yourself or another person. So also the desired instruction that appellant desires based on their brief was the shoot and continue to shoot instruction. The Texas Court of Criminal Appeals has identified that if a defensive instruction isn't explicitly stated in the penal code, then it shouldn't be included in the jury charge. And that's exactly what the trial court did in this case. They did not include a defensive instruction that was not explicitly included in the penal code. With regard to the new trial issues, in the motion for new trial, appellant claimed 2 issues based on Texas Rule of Appellate Procedure 21.3, and those are that the jury was coerced into a verdict and that the jury determined their verdict by lot or any other manner not based on the facts or the evidence. In the motion for new trial hearing, to state it plainly, the appellant didn't provide any evidence that either of those claims had been met. The juror by lot and coercion claims, I guess, were referring to the jury instructions, the statement by the judge that the appellant is claiming that the holdout juror was coerced into making a verdict. What I would say to that is that, first of all, a motion for new trial doesn't preserve a lack of an objection at the trial itself. The record shows that the first person to approach the trial court with regard to anything Arredondo might have said was the state. They had an off-the-record conversation regarding the situation over whether or not they believe Arredondo might have been influenced by any comments made by the trial court. And that's all we have of it on the record. And the Texas Court of Criminal Appeals has held that if you have the opportunity to object to something at trial, it can't be raised for the first time in a motion for new trial if you had the opportunity to object to it. Now, the off-the-record bench conference that occurred regarding Arredondo's reaction to the jury poll was after the jury had already retired to consider the verdict after the supplemental instruction. So based on precedent that's included in the state's brief, the state would argue that not only was that claim not preserved for appeal on the first time because of a lack of an objection at trial, that it was untimely because you can't bring it up for the first time in a motion for new trial. So we don't even get to the factual circumstances regarding whether or not the supplemental instruction may or may not have been coercive. And it's the state's position that the supplemental instruction of, okay, retire to the jury room and come back until you have reached a unanimous verdict isn't coercive based on precedent that I've cited or the state has cited in their brief.
Are you familiar with any case law at the state court level that would indicate the manner in which Judge Purrier polled the jury was improper?
Not any that had overturned the conviction or that had identified that it was in fact coercive. I think that the best case to highlight regarding this issue would be Barnett v. State, which both the state and the appellant cite in their briefs, which is a Fort Worth Court of Appeals decision. In that case, the jury came back 11-1, and the judge said, or it was a multiple counts. It was 11-1 not guilty on one count and 11-1 guilty on one count. And there were two different jurors for the holdouts on each count. And the judge stated, okay, well, we have a problem with both of you. Come back when you have a unanimous verdict. Well, that's clear. That's definitely distinguishable from the present case and other cases the state has cited in its brief, specifically stating that the people who have not consented to a unanimous verdict must go back and consent to a unanimous verdict can be reasonably believed to be facial coercion, especially given that when they did come back, the verdicts changed to unanimous, with the one holdout jurors both changing their minds to make the verdicts unanimous. So it was clear that that had some kind of effect on the juror's state of mind. Going back to
the jury is instructed that the verdict must be unanimous. So how can it be coercive to remind them that you must comply with the trial court's charge and render a unanimous verdict?
Well, in the present case, it would not be by simply telling them that you have to have a unanimous verdict in order to have a verdict. The Barnett case is distinguishable because it specifically singled out the two holdout jurors. That definitely didn't happen here. It just so happens that there was one holdout juror that said that that wasn't his verdict at the time. The appellant makes the argument that use of the word "you" is evidence of coercion, that it was directed toward Mr. Arredondo. I'm not sure. I mean, it's possible that the trial court could have worded it differently, yes, but given the context and all the circumstances, the state believes it's pretty clear that "you" was referring to the jury as a whole.
And is there any evidence in the record that Judge Puryear was directing his comments to that specific juror? Because when you return the jury to the jury room to continue deliberations, you're asking the jury, return when you have reached a verdict, you in the plural, you, all 12 of you.
The record doesn't contain any explicit evidence that Judge Puryear was directing his instruction explicitly toward Arredondo. Now, I will say that Arredondo was asked a couple of times whether or not his verdict was no. The state argues that that's just the judge confirming that that was the case. The difference between the present case and some of the cases the state cited in its brief was that in this case, this was the first time that the jury had come out of deliberations in order to be polled. So it's reasonable that the trial court would make sure that they did not come back with a unanimous verdict by maybe asking one person twice whether or not that was in fact their verdict or not. In other cases, the jury had come back multiple times indicating that they were still split. And in that case, if the judge had repeated their instructions to a particular individual, there would be more of an argument to state that it was coercive toward the lone holdout juror. But that's not what happened here.
So here you have a situation where there wasn't a note submitted by the jury indicating that they were deadlocked or could not.
Not in our case, no.
Jury announced that the verdict was ready to be presented, and then by polling, it was determined that there was a juror who had not consented to the verdict.
Correct. Additionally, I'd like to bring up the Arredondo affidavit. It's the state's position that his affidavit, and I apologize, Your Honor, if you see that message. It's the state's position that Arredondo's affidavit was reflective of jury deliberations and should not have been considered at the motion for new trial. The judge properly excluded that because even if you did consider what he said, it states that he still came to a guilty verdict based on the facts of the evidence, and there's no evidence that fellow jurors were forcing him to make a decision or that the judge specifically had any influence on his decision to change his mind. Another factor I would add to the jury coercion issue is that in this case for a murder trial, the jury came back only shortly after 2 hours of deliberation. And regardless of anyone's opinion on the evidence. That's a pretty short amount of time to come back for a murder trial. So you can't make the argument that the jury had not sufficiently deliberated, and that, instructing them to come back with a unanimous verdict because they need more time to deliberate wouldn't be an unusual case.
Counsel, will you address the motion, the appellant's issues on the motion for new trial not being public and the defendant not being able to be present with his attorney or communicate with his attorney or view the photograph that was presented there and consult with his attorney about that photograph?
Yes, Your Honor. I believe that the relevant statute with regard to this issue is 3303, and that's that the defendant has the right to be present at jury trial hearings. Court of Criminal Appeals precedent has stated that a motion for new trial hearing is not a part of the trial. There has also been an additional precedent that says that if a defendant isn't present at a motion for new trial hearing, it's not a violation of 3303 unless the appellant can specify some harm that he has incurred. In the present case, the appellant hasn't specified any harm that he's incurred by not being there. They merely speculate that harm may have occurred. That's not enough. A plain reading of the statute.
Couldn't the disposition of a motion for a new trial essentially affect the defendant's trial rights? For instance, if the motion is granted, then you're right back to where you started.
Well, that would be correct, and the rest of the issues that we've been discussing would lead to affirmation of the guilty verdict. The plain reading of 3303 states that a defendant must personally be present at trial. The state would argue in this case that the defendant was personally present. Now, prior case law has stated that the lack of presence of a defendant at a motion for new trial was error. However, in those cases, the defendant wasn't even present telephonically. He was just simply not there. So that was what distinguishes the present case from those past cases.
Mr. Massey, if you'd please wrap it up.
In short, the state would argue that the appellant did not prove their claims in the motion for new trial, and additionally, their claims in the motion for new trial were not preserved for review, and that the conflicting evidence was resolved by the jury in favor of the trial verdict and was viewed in the light most favorable to the prosecution.
Thank you very much. Ms. Orr, we have a clock. If you're ready for your 5-minute rebuttal.
Yes, Your Honor. So I would first start responding to the lack of my client's presence at the motion for new trial hearing. It was during the offering of the only exhibit showing the location of Mr. Kennedy's body that Mr. Gonzalez was not present at the hearing. His phone call had been dropped. The phone went dark. So that was very important that he be present during the offering a defense exhibit number 25. In addition, I'll direct the court to Brandley versus State out of the Court of Appeals for Dallas. It's February 16th, 2015 case, cause number 02-2615, in which the court, citing authority, says that having a hearing outside the presence of the defendant implicates their rights to confront the witnesses, to effective assistance of counsel, and they go through citing Court of Criminal Appeals case Ruiz for that proposition, as well as numerous other luminary appellate courts. As for
does that case involve a motion for a new trial setting, or is it just either a pretrial or trial matter?
It is a motion for new trial. That's all it's about, Justice Trotter.
Is that case cited in your brief?
No, I was looking that up. I cited a different case in my brief talking about Trevino versus State, which is a Court of Criminal Appeals case where they talk about the motion for new trial being a critical stage. But I will submit that in a post-submission letter both to my opponent and to the court for your edification.
Thank you.
You're welcome, Chief Justice. In addition, in the state's brief, they do acknowledge that when my client saw Kennedy making good on his promise to kill Bernard at page 11 of their brief. That's when the shooting began. I'll remind the court of the increased threat force. I will also mention the only person who said they didn't see the knife was Nick Gonzalez. Everyone else saw the knife deployed, and Nick heard his father say, "Don't stab my son." There's no doubt a knife was being used, as well as the truck and a brick and the posse that was coming. And
Was all that though before he went back, before things calmed down and he went back to the truck?
And then he came out and started fighting again, Justice Williams. He re-engaged in fisticuffs and punching my client. Apparently,
But not with the knife.
Apparently not.
Okay.
He apparently did have the knife on his person, though, because then it was found with his body. In addition, my client saw the knife, and that's also in the record, and is in his statement. Bernardo seeing the knife is in State's Exhibit 2. And I'd like to remind the court that immediately necessary deadly force can be deployed until the danger is past, and the danger had not passed at all, Your Honor. Defensive property is authorized by 9.42 of the Texas Penal Code, so it's properly a subject of instruction. I would say the jury came to a quick verdict in this case because it was not properly instructed on this right to defense. They were misled into believing that Mr. Gonzalez had the duty to retreat, that he had this duty to stop fighting, and that wasn't the law at the time. He was entitled to keep shooting until the danger was past, but the jury was not instructed to that. The case that stands for the proper way in polling the jury is Batten out of the Court of Criminal Appeals. It's in our brief. It's at 549 Southwest 2nd, 718, footnote 5 in particular details that. And I would say this juror was singled out as recognized in the Howard case out of the Court of Criminal Appeals. When you get the division by the questioning that the judge employed, singling out this one juror as the holdout juror, that the court says the trial court might engender coercion by actively identifying jurors with minority views and tacitly instructing them to re-examine their perspectives. And that's what happened here, I would suggest to the court. And finally, I did mention that the motion for new trial hearing my client, we did bench warrant him timely. That was denied. We did ask for him to be present. We complained about the proceedings being closed. And for those reasons, I would respectfully request, under the proper evaluation of the evidence, the neutral light, considering all the evidence, that this court reverse and render or grant my client a new trial. Thank you very much.
Thank you very much, Ms. Orr. The case has now been submitted. The court will be in recess until 11 a.m. Thank you.
Thank you. Thank you, Mr. Massey.
Thank you, Your Honor, counsel.